Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Okay, guys, we are here tonight. We've just teleported. Hopefully, all of you have teleported. I hope. I'm praying. I'm believing that you teleported. That would be nice if you did teleport. I'm hoping you teleported. I really am hoping you teleported because we are going to start diving into the Karen Reed trial. And we are going to be doing the first trial. And it is day 7. We don't have any of the earlier days. I have been working very hard. Can one of my mods please say hello in regular chat just to make sure that my live chat is functioning? I am going to be doing a little bit. I've got to move things around a little bit. Give me a split second because it's going to have to be a little different than what I normally do. Mods, I will not be able to see live chat, so if I need to go to Discord, please put it in studio chat because I have to put up a big screen with this document. Okay, so what I'm having to do is do this. Okay, so hello, everybody. Thank you guys for joining. So let me share this presentation. I'm going to share. I'm going to pop it up here. And, or do I want this? Nah, I don't want that. I'm going to leave this way, put that there. There we go. And let me see. Let me see how this is going to go. Okay, guys. So what I'm going to be doing is we're going to be going through each sidebar and I'm going to be reading it, and then I've got commentary for you, and we're going to sit here and I'm going to explain to you my thoughts. So give me a second. I've got to just do a little bit of arranging. Just give me a split second to do that. I've never done this way, so we'll see how it works, okay? All right, so I will be looking off on the screen to read this. Oh, actually, let me do this. Let me do it this way. I'm just getting everything set up, guys, so everything fits. Okay. So let me read this, okay? I will be looking off to read. The court, yes, maybe I'll just put it in front of me and move everything else to the side. I'll just do it that way. There we go. There we go. There we go. Go. There we go. Yay, I got it. Thank you, everybody. Danny Hill, thank you for joining us. Angela, June, everybody joining us. Thank you very much. Okay, guys, so I got to figure out how to, I don't know how to get this cleared off to where you don't see the edges, so that's okay. All right, so what we're going to do is we're going to do the sidebars, and then I'm going to read you my personal commentation. I'll explain the importance of the sidebar, why it happened, what happened, and all that wonderful stuff. Mods, I'm going to need you to handle all of the comment postings, and I need you to handle StreamYard. I thank you. Thank you for removing it. Thank you for taking care of all that. That is going to be all on you, okay? Because that way I can actually read everything. Actually, I just think I figured something out. I did. Woohoo! I figured something out. Okay. So here we go. This is day 7. How is my sound? Am I good? All right. This is day 7. Miss Laughlin, Your Honor, may we reapproach the sidebar? Court? Yes. Jurors, when we come to sidebar, please feel free to stand up and stretch. Okay. Laughlin. Your Honor, the Commonwealth would like to object to the defense's counsel opening. Contrary to the rule of this court, they opened with suggestions that a third-party culprit. Twice, the defense counsel represented Karen Reed was framed and that she was ambushed and that somebody else did it. The Commonwealth would like to object, given the ruling of this court, that there would be no third-party culprit claimed within the opening. I will not say court. It will just be my voice. Well, what do you want me to say? Just say openings are not evidence. I remind you, openings are not evidence, clerk. Sorry. One of the jurors needs to go to the bathroom. Yes, we're going to take a recess. Jurors, why don't we just take a 15-minute recess? Whereupon the jury exits the courtroom. Brief recess. And they resume. Court, this is probably a good time to continue this, Laughlin. Yes. So if you could note that the Commonwealth's objection and given the limiting instructions, reminding the jurors that the opening are not evident. Okay, Mr. Yannetti. So I don't think I did anything improper. I think that I couched it in terms of the lack of investigation that they did and did not name any third-party culprit at all. But I have no objection to the court solution. Court, okay. You did a decent job, but there were a couple of times that you pushed it, all right? I will instruct them that when they come back, that what I'm going to say is we'll take a 15-minute recess. Who is your witness? Do you have more than one for now until 1 o'clock? Or do you just have one, Mr. Lally? Probably just one, court. Okay. And that is Paul O'Keefe. All right. So we will take a 15-minute recess. Thank you. All right. This concludes. All right. So now let me bring forth, come on, my commentary. So the Commonwealth objects to the defense's opening statement, arguing the defense counsel improperly suggested a third-party culprit theory, contrary to the court's prior ruling limiting such argument during the opening. Now, the Commonwealth's position, ADA Laughlin, defense counsel twice suggested Karen Reed was framed, she was ambushed, and somebody else committed the crime. Now, the Commonwealth argues that these statements violate the court's pretrial ruling prohibiting the third-party culprit claim and the opening statements. He's requesting objection be noted, limiting instructions, reminding the jurors that the opening is not evidence. Defense's position, Attorney Yannetti, asserts he did not violate the court's ruling. He argues his statements were framed in criticism of the investigation, not the accusation naming a third-party culprit. He did not identify a specific alternative perpetrator. States he is not objecting to the court's giving a limited instruction. Now, the court's analysis, the judge acknowledges the defense counsel did a decent job. Oh, wow, let's give him a little applause. She did a decent job. However, there were a couple of times that you pushed it, indicating the court agrees with the defense came close to the prohibited line. The judge appears to incline to resolve the issue with the basically curative instruction rather than sanctions or restrictions. The court will note the Commonwealth's objection, instruct the jury upon their return. Opening statements are not evidence. No further correction or action is ordered and no findings of misconduct were made. Now, let's talk about some procedural notes. A juror needs to use a restroom, prompting the judge to recess before the completing of the sidebar. Sidebar continues after the jury's exiting, and the court will briefly address the scheduling. That we know. All right. That is the first sidebar. Let me go over here and let me get the next page, which is 108. We figured out something, and I'm so glad we did. All right. I'm going to read a little. Hold on a second for the siren to pass the court. Mr. Lally, does it make sense that I give instructions at this point? Let me see counsel at the sidebar. Mr. Lally, yes. Whereupon the sidebar conference is as follows. Court, I don't know. I'm having trouble, court reporter, with regard to the witness. So there were in the room around the same time, but they did not see each other. The court, okay, that's what I thought. So the next witness, there is a conversation between mere meanings of Mr. O'Keefe and Aaron O'Keefe, the defendant, in regards to what happened with this witness may be hearsay. The court, okay, so no instruction, Lally, unless the court feels it's appropriate for the 2021, which I'm fine with that. If that's what court, I can do that in the final charge. Lally, okay, Yannetti, just to confirm, if I may address the court, I'm just making sure. There was some indication that the report of Paul O'Keefe had told the police that he did not go over to the Karen and John's place because they were fighting or something like that. That's what you're referring to in the terms when you say they're not seeking to elicit from him? Lally, correct. So he gets that information from his wife, not directly from your client. Yannetti, okay. Lally, but no, I'm seeking anything about Yannetti, then that's fine. Court, so you don't want me to draw attention to the instruction, Lally, correct. The court, okay, thank you. Let's quickly, briefly talk about this. So the sound is good. We're all good with the sound? Okay. So whether to anticipate statements connected to Paul O'Keefe's testimony would be hearsay, and whether the court should give a limiting instruction to the jury is what the issue is. So the Commonwealth's position, or Lally, confirms the two witnesses were in the same room but did not see each other. The next witness, Aaron O'Keefe, had direct conversation with the defendant. Paul O'Keefe only learned certain information from his wife, not the defendant. Hence, we have a hearsay statement. Therefore, any such statement would be hearsay if elicited from Paul. So he cannot talk about that on the witness stand. He is not seeking to introduce it. He's not wanting to limiting instruction that would highlight the issue. Is fine with the court addressing hearsay generally in the final charge. Now, the defense position, Mr. Yannetti, seeks clarification about the police reporting, suggesting Paul said he didn't go to Karen and John's home because they were fighting. Wants confirmation from the Commonwealth is not introducing this statement. He wants to make sure he's getting his clarification. The Commonwealth confers Paul only heard from his wife on this account. He will not be elicited. The defense accepts this and raised no further objection. Now, the judge does confirm no limiting instructions will be given now, and general hearsay instructions can be included in the final jury charge. Court's ruling and actions are no limiting instruction. Hearsay principles will be covered in the final charge, and sidebar concludes. Now, here's the significance in the procedural process. The sidebar quietly resolves potentially prejudicial evidentiary issue, prevents the jury from hearing a double hearsay about alleged fighting between Karen Reed and John O'Keefe, ensures the Commonwealth avoids introduction statements like proper foundation, and protects the defense without drawing unnecessary attention to the topic. Okay? Next sidebar. Oh, I need to do this. Sorry. Next, Mr. Lally. So they're not marked exhibits yet, but what I'd like to do is show witnesses some videos from Ring, whether she's on the Ring footage or it comes in from that day. So I'm just, is this going to be an agreed upon exhibit? Is this going to be agreed upon exhibit? She says it twice. Mr. Lally, I believe so, but just explain this one. Now, let me do something. I noticed something's off on my thing. Give me a second. There we go. Let me get over here. Which Ring video is this, Mr. Lally? Probably I think there was the one when he arrives back at home from the hospital, along with his friends and Miss Roberts. And then there is when Miss Reed arrives with her father, and then basically just to identify who these people are in the video. And then there's a couple just in reference to the sort of snow removal from the driveway when that occurred. Yannetti. We have no objections to that, Court. Fine. So let's mark it as exhibit. Yannetti, that's fine. Court, that's fine. Okay, so a lot of these sidebars will be based on what is called exhibits, setting up the exhibits. Okay. So in this particular sidebar, the sidebar, Commonwealth is seeking to show the Ring camera footage to a witness. The court is clarifying the exhibit status and agreement in the parties. So, issues presented here are whether a certain Ring camera video can be shown, excuse me, to an upcoming witness and whether they should be marked as exhibits before being displayed. I'm putting vanilla extract in my coffee. I like to do that. I don't like the fake vanilla. I get the real vanilla bean. Sometimes it tickles my throat. So the Commonwealth's position, Lally, video is not marked yet as an exhibit, and the Commonwealth wants to show the witness. So the footage of O'Keefe arriving home from the hospital with friends and Miss Roberts, the footage of Karen Ree arriving with her father, that's the second one, an additional clip showing the snow removal from the driveway and the timing of the activity. They must identify the individuals in the video is the reason for them showing the videos. Now, this believes that the exhibit will be agreed upon, but is not fully certain. So the defense position, Jackson and Yeti, Jackson asked for clarification. Which Ring video? Because there's a multiple Ring videos. So he wants them to specifically identify the video. Lally does specify the clips and they have no objection. The judge asked twice whether this is an agreed upon exhibit. She's trying to make sure that this is a clearly agreed upon exhibit. Once the Commonwealth and the defense confirm no objection, the judge is satisfied. So the judge marks it as exhibit. Now, this is a procedural sidebar and it accomplishes several key procedural steps. It assures proper marking of the video evidence before it is shown to the jury. Now, one thing we need to realize in a little bit, we're going to start seeing they have a lot of confusion with the labeling and numbering of the exhibits. So this is going to become critical in the future. It confirms the defense consistency and avoids later objecting about a surprise or improper foundation. And it clarifies which specific Ring clip will be used for the purpose of identification, and it streamlines the upcoming witness examination by resolving the exhibit issue in advance. So now the next is going to be 220. All right, the court. So do you expect Detective Lank tomorrow? I'm sorry. Do you expect Detective Lank tomorrow? Lolly, no. Okay, because whenever he testifies, I'd like to voir dire on the issue of the prior allegations. Lolly, sure. So just give us enough of a heads up, Lolly. I will say Friday at the earliest. Okay. Who do you have tomorrow just because it helps me prepare? Lolly, sure. So tomorrow I think we'll just continue with Officer Sheriff and then we'll have Officer Mulaney. And then essentially is going to be a number of firefighters court. Okay. Lolly. So we're going to have Timothy Nuttall, Anthony Fumetti, Matthew Kelly, Francis Walsh, Katie McLaughlin, and probably depending on how far we get with all that, I'm not sure how much cross there's going to be for those people. But I think it would be also Gregory Woodbury, then Daniel Whitley. I'm not saying we'll get onto all of these tomorrow, but these are basically, I'm going through the paramedics that dealt with Mr. O'Keefe, and then I'm going through the paramedic that dealt with Miss Reed court. Okay, Molly. Mr. Whiteley and Mr. Becker would be the last two there. All right. Anything regarding any of the testimony that you expect limiting instructions on or any evidentiary issues that we need to consider or concerned with? Yeti, I don't think so, Judge Lolly. I think even exhibit-wise, for the most part, it would just be run reports and a lot of the same photographs as far as where the body was and when they arrived there and that kind of thing. All right. Anything that needs to be pre-marked will be marked tomorrow morning, Lolly. That's fantastic. Yannetti, 9 a.m. tomorrow. We'll be here at 8:30. Court. Yeah, thank you. Court adjourns for tomorrow. Okay. So, issues presented. Not really much. They just confirmed Detective Lank will testify when, because the judge intends to do a voir dire on prior allegations before he testifies. Now, the detailed witness schedule for the next day. Notice the anticipated evidentiary issues and limiting instructions. Coordination on pre-marking exhibits. So everything is all copacetic. Everybody is happy. So now we're going into day 8, which let me line up that docket. Day 8, page 41. May I approach, Your Honor? Yes. Mr. Jackson. I got to go up. The court. So typically we play something only once. You played it twice and you were ready to play it a third time. You need to ask permission to do anything like that, okay? Jackson. Sure. Court. You can't just keep playing things twice, okay? All right. So you said you were going to keep focusing on the 26 or whatever it was. You are planning to show it for the second time, Mr. Jackson. This one, it will probably, it's hard to see the first time. I'll do my best to highlight what I'm asking him to look at. I may play it twice, but no more than twice. What is it? Jackson, it shows Jennifer McKay pass by an SUV and then goes into the home. Can you freeze it as it goes on instead of showing it twice, Jackson? I will. Once you show it more than once, it gets to argument, okay? I'll do my best, Jackson. Court. just once. Just once. I'm not saying I disagree with some of the orders of the court, but what I am saying is I am struggling with her tone. Okay? So the issue presented here is whether defense counsel may play a video clip multiple times during questioning and what procedural limits apply to avoid improper argument. So the judge's notes, the video has already been played twice. Defense appears ready to play it a third time. The court emphasizes counsel must ask permission before replaying the exhibit. Typically, we only play them once, she states in quotes. Repetition risks turning the presentation into an argument and not evidence. And that is the big concern here. But unfortunately, with some of these videos, the clarity and the fact that a lot of them look alike, they need to see them twice to be able to understand exactly what they're looking at or what is going to be asked of them about said video. Now, the defense position, Attorney Jackson, acknowledges the court instructions, but he explained the clip is hard to see on the first viewing, Your Honor, and it may need to be played twice, but no more than twice. He will try to highlight the relevant portions during the questioning. The court asks what the video depicts, and Jackson tells him Jennifer McCade walking past the SUV and entering into the house. The judge suggests an alternative freeze frame. This is relevant moment instead of replaying the entire clip. The court reiterates, show the video more than once, risk becoming an argumentative. Direct quote, once, just once. The defense may show the video one time. It clearly needs counsel to use free frames and not repeated playbacks. So what is the procedural significance of all this? Repetition, in legal terms, argumentative. So when you have repetition equals argumentative, courts guard against using a video replays to persuade the jury rather than to elicit the testimony. So sometimes attorneys have in the past played a video multiple times to create a bigger impact and to influence the jury. Permission is required. Even admitted exhibits cannot be replayed at will. Freeze frame as a compromise allows clarity without the persuasive effects of repetition. So that's where that went. Next. And the next sidebar is at 146. It says line 146, but we usually have to go back a little bit. What is the objection? I love it. She gets real snippy with him a lot. Lally, I don't know whether the witness has a basis of knowledge to document casualty as it comes through injury that he observed. The court. So if you can build a foundation, you can do that. And don't ask for demonstratives or having him repeat something. It's only one time. Jackson, I don't understand what the court's issue is. If people don't pay attention to it, then are you pointing your finger at me? Ooh. No, I'm pointing my finger at the jurors. If the jurors do not see what he did, there is nothing argumentative about saying, what did you do? I want to make sure everybody saw what he did. Lally, I'm not sure. Or they've seen it once. Jackson, I don't know what they've seen it once. Court, well, that, as a matter of fact, they did see it once, Jackson. Court, I was watching. It was good enough, and it wasn't enough to respond to it with demonstratives. Jackson, fair enough, Your Honor. Just to dovetail off of what Mr. Lally indicated, this witness testified that for about first 30 minutes of his testimony about the extensive medical background, I feel like it's a waste of time, but I could ask him a few more questions about whether or not he's seen many fights before or the product of that. The court, you can ask him about causation as well. Fair enough. End of sidebar. All righty. So, whether the witness has sufficient basis of knowledge to testify about causation of injuries and whether the defense counsel may ask the witness to demonstrate or repeat physical action for the injury. The Commonwealth's position, Lally, objects to the grounds that the witness may not have the foundation to testify about casualty of injuries. The concern is the witness observed the injuries may not be qualified to link cause to the effect. So the court's initial ruling was the judge defense may ask about causation if they first build the proper foundation. So the judge instructs no demonstrations, no repeating of physical reactions, only one time. This ties back the court's ongoing concern about repetition becoming argument. Jackson pushes back. He doesn't understand the court's issue and argues that if the jury didn't see the action clearly, he should be allowed to clarify. When the judge asked if he was pointing the finger at her, Jackson clarifies, I was pointing at the jury, Your Honor, not you, the judge. I'm loving it. So, Jackson continues to argue. I'm going to get some gum, y'all. I don't like to chew gum, but it keeps me from coughing. He wants to ensure the jury did see the action. Now, the court analyzes. They've seen it once. That's enough. Demonstrations are unnecessary and risk becoming argument. And she was watching the jury and believes the first demonstration was sufficient. Jackson notes a witness spent 30 minutes testifying about his medical background. He suggests this was extensive, but acknowledges he can ask more questions if needed. He proposes whether the witness has seen many fights, whether he's seen results of said fights, building a foundation for causation testimony. Now, the judge is going to permit the question of causation and the question about the witness's experience with injuries and fights. But she maintains no repeat demonstration and no reenactment. Now, why is this so significant? The foundation is required for causation testimony. A witness cannot testify about what caused an injury unless counsel establishes their training, experience, and basis of knowledge. Demonstrations are tightly restricted. They represent repeating physical actions such as undue emphasis, arguments, or will confuse the jury. The judge is actively monitoring the jury's perception. Yep. It is. So let me pop up. Uh-oh. Give me a second. Now, June. Guys, we did go through 9 and 10 yesterday, so we're going to skip to 11. Where's document 11? Why can't I find document 11? There it is. Okay, so we're going to skip to document 11. I mean, big in it. And then I need to, give me a second. I need to do some skipty-skoo on my thing here. Because we went through 9 and 10 yesterday. So I need to get to document 11 in my notations. I did a lot of research on this, guys, because I wanted to give you the best that I could. So let me get to 11. Y'all take a stretch break. Everybody stand up for a minute while I look for document 11. Gosh, that's still on 9. 9 and 10 had a lot yesterday, guys. So we went through those yesterday. That's 10. No way. We may go through 9 and 10 again. That's 10. 10 to 10 to 10 10 10 10 10 to 10. I'm getting close, guys. Whew. 10's, I'm still on 10. 10, it had a ton of, 10 was like 400 pages, I believe. 10 was a big day. There we go. Document 11. Right. Are y'all enjoying this? Is this something that y'all are happy that I'm doing? Why do I not have any comments? Oh, there they are. Are y'all good with this? Are y'all liking this? Okay. Lally, Your Honor, what I'd like to do just to make Miss Gilman's life a little bit easier is if I could publish them to the jury, referring to the numbers that are currently on them, and then have them marked as next subsequent exhibit. Now, understand, guys, here, we had a lot of procedural crap that went down in trial 1 with keeping the evidence in order numerically, alphabetically. They could not keep anything clean. It was so frustrating. The court, all right, so you want to publish them first and then we'll mark them? Lally, just so I can refer to them as exhibit. Court, is there any objection to doing that? Jackson, no. The clerk, can we all stay here for a second? FTR is down right now. The official court report obviously is here. Tori and I are working on the FTR, but it's not recording as of right this second. Okay, that's their device that they use to record. It records everything, and then they have that mic, and they're doing the corrections in the mic. Okay, you can see that the clock is frozen. All right, thank you. The sidebar now concludes. So this is important. Why? They have to publish the exhibits to the jury using numbers currently printed on them, then renumber them afterwards as the next subsequent exhibit, making things easier for Miss Gilman, the courtroom technology operator. There were no objections. The FDR is down. The clock is frozen. The system's not recording. The sidebar conferences must be recorded. Exhibit numbering discussions must be preserved. And the judge has already expressed concerns about sloppy exhibit handling. So the judge pauses and acknowledges the issue. The clerk reporter concerned that if Lally verbally refers to the exhibit by their old numbers, the record will reflect those numbers. And then the court will change the numbers afterwards, creating a confusing and inaccurate transcript. That is very important. See, what a lot of us don't realize is what's the big deal? They're saying evidence number 103, exhibit number H. It is vital because the recording of it, both in the audio recording and the physical recording of it, is very important. So is that what the clock is about that we see up front? I always wonder. Yes, that is that clock. When that clock frees, that clock is tied with the timing of the recording. So, yep. So procedurally, it's conflicting exhibit numbers, confuses the jury, confuses the appellate courts, transcripts that are contradictory in the final exhibit list. So it is vital. So if Lally said exhibit 308, but later it becomes exhibit 17, the transcript will be a mess. The FTR failure raises the stakes. When the digital recording system is down, the clerk report transcript becomes the only record. Accuracy becomes even more critical. So the judge is enforced discipline, fits the pattern. No sloppy exhibits handling is very, very important to her. Yeah, this is really, they have a lot of issues actually with this. They really, really do. And it gets very frustrating. So, Your Honor. Oh, by the way, somebody last night, every time they heard the word sidebar, they took a drink. Y'all want to play along? So, Lally. So, Your Honor, in the interest of time, I can tell the court that the disc contains a video we were just talking about. I would like to have it marked as exhibit before I play it for the witness, who can then authenticate it because he sent it. If there is any issue with that, Jackson, no. From a prosecutorial, I can't even say that, prosecutorial standpoint, I don't care. I just want to make sure that I understand that the disc contains 2 videos. Lally, I think it's more than 2, Jackson. You think it's more than 2? Lally, well, they broke it up into, it is all sorts of the same footage, but it's all broken up into, no, simple, small snippets. Lally, yes, I don't have a problem with it. All right. While we're on it, exhibits, he testified to the first paragraph being photo number 20, and then 20 is Baker's report from the other day. So did you inadvertently give him what had been previously marked as 20 in that pile just now without any sticker on it? Because these photos, Lally, I may have. Court. I have it. We started at 21. Is that right, Tori? So if there's an issue with 1 in there with a sticker on it, that's 20. Yes, we're removed. He indicated what all the others were. Lally, okay, court. He said there were 2 of them. So it's probably one of these. Anyway, it's probably a duplicate. If you all want to look at it, that a break and figure it out, you need to do that, Lally. Okay, so you can go ahead and put that in. Okay, sidebar concluded. Procedural. And thank you, June. I figured it out. It's just, unfortunately, my dyslexia. I'm doing really good at reading these because I've read it already. I have no idea what all that's about. Okay. My mods are having a sidebar of their own. So, the importance of this, marking the video disc as an exhibit. Lally wants the disc marked before playing. He says a witness can authenticate it because he sent the videos. Note, the disc contains more than 2 videos broken into small snippets of the same footage. The defense has no objection, just wants to confirm the disc content. The judge accepts the plan. This will be marked as an exhibit, then played for the witnesses. This is standard procedure to authenticate, mark, publish. Now, this is procedural, and sometimes people get confused about it. So you have to authenticate it, mark it, then publish it. Okay. This judge pivots to a separate exhibit problem. The judge is concerned that the witness testified that the first photograph he saw was photo number 20, but exhibit 20 is actually Becker's report, not a photograph. The judge suspects that Lally may have accidentally handed the witness the wrong item, possibly a photo that once had number 20 sticker on it, but was later removed. Oh, are those smiley faces? They're too small. I need glasses. The court of Clerk Tory confirms the numbering started at 21. If something in the pile starts at 20 sticker, the leftover or duplicate. So that's all procedural. They got it all figured out, but it's vitally important that they keep these procedural things together. So it appears there's another situation. Lally, Your Honor, the Commonwealth seeks to introduce this and admit the next exhibit. Okay, whereupon the scene of the video entered and marked as exhibit number 33 as evidence. The court reporter, exhibit 33. Court, thank you. Lally, my apologies, Your Honor. May we reproach briefly another... Okay, jurors, feel free to stand up and stretch, whereas sidebar conference was as follows. Lally, I believe what happened was Madam Court Reporter in it. Oh, you didn't. You're blaming Madam Court Reporter. Madam Court Reporter inadvertently marked the first photograph in the set today as 20s, so now we have two 20s. Therefore, we go on. No, she did not. She has 429. That's yours. Lally, oh, I'm sorry. This is where we started today and marking them. That's probably a duplicate. Little. I think you said we had 13, but actually marked, that might just be the last one. Lally, I just don't want to keep marking exhibits and further compound the problem. That's the only reason I asked you, court. These all have today's date on them. That was pre-marked by US 20. So you can, Laughlin, do we already have a 20 court? We do have a 20. It's Baker's report. Laughlin, could we admit this one at least as subsequential to the older exhibit? Court, how about if we do 20A because he has referenced it as 20? I got a bug bite. Okay. So at least we have the number that corresponds with the juror saw. Okay. Is there any objection to that? Jackson, no. We'll do that. Hand it to Madam Court Reporter to be marked. Lally, Your Honor, the court's permission, may I publish what has now been marked as I believe is exhibit 20A? Mr. Lally, 20, sorry. The last exhibit on the disc. If I could publish it to the jury, yes. Lally, Miss Glidman, could you just pause it right there? All right. So, again, we have more procedural problems. The court reporter accidentally marked the new photo as Exhibit 20, citing two Exhibit 20s, which could confuse the jury and the record. He addresses the issue before continuing. Now, the court's investigation of this, the judge quickly checks the exhibits. The photo in the question has 4/29 date on it. That means it was pre-marked by the Commonwealth, not marked today. Therefore, the court reporter did not create the duplicate. Don't blame the reporter. Just take the fall yourself. Fall on the sword yourself, attorney. It will always look better in the end. Duplicate 20 came from the Commonwealth's own pre-marked file, not from the court. This is consistent with earlier problems caused by mask-free marking. And if you remember last night, there was a lot of problems caused with the mask-free marking. Clarification from the counsel. The defense little notes that they believe that they had 13 photos, but numbering may have drifted. Suggests that the dispute photo might simply be the last one in the set. Commonwealth Lally says that he wants to avoid the compounding the numbering confusion, and they all agree on 28, and we move forward. There was more procedural stuff in here that I cared to admit, and it became very frustrating. Question, answer. Okay, here we go. We have another. All right, so we're still in session. So in presenting the exhibits to be marked, please take them out of the plastic. Oh my God, why do we have to keep going on and on about exhibits? Y'all should know how to do your jobs. Take them out of the plastics and out of the envelopes because the actual item itself gets a sticker on it, not the plastic. We are having all sorts of difficulties. FTR's not working. I'm not sure if we're getting any internet here. Are we all set with this? Is this something? Do you want to use the flash drive that you put in? Would that help? Lally? No, I think the issue is sort of the size of the video. So bringing it up can be, although my issue is I was standing over there, I couldn't really see anything as far as the screen. It doesn't appear that dark when you put it on the laptop. Court. I couldn't open any of those this morning on my work computer. All right. Why don't we take a 10-minute recess? We're upon the recess. Court. Mr. Lally, are we set? All set? Lally, yes, Mr. Officer. It may be a little bit, but if you could please put the lights back on. Thank you, sir, Mr. Lally. And they resume. So again, Lally messes up and blames the court reporter. Yep, this has been multiple times in this court that he has done that. So the transcript times of the court still in session. The judge gives instructions on how the exhibit must be physically presented for marking and deals with the cascade of technical problems. The FTR, the courtroom's digital recording system, is down yet again, and the internet may be down as well, and the video file is too large to play smoothly. So the judge begins with procedural reminders. Exhibits must be taken out of the plastic sleeves and out of any and all envelopes, and the sticker must go on the actual item itself, not the packaging. I mean, I don't understand. Oh, I had itch. I do not understand how these lawyers do not understand this. This is procedural in most courtrooms, I would presume, all courtroom. Technical failures do arise, and the FTR is not working, and she assures whether the courtroom has any internet. The effect will the recording exhibit displays video playback and the judge's ability to review the material. This is significant because the FTR is a backup to the court reporter. If both fail, the record is compromised. The judge must pause to protect the integrity of the proceedings. The Commonwealth says that the issue is the size of the video file. Large file load slowly and display poorly. He notes that when standing at the podium, he couldn't see the screen clearly. The video looks, hold on. My pillow fell. Oh, sorry guys. I have a pillow that I put under my knees. Okay, so the court projector often distorts brightness. Large files lag or freeze, and counsel cannot see what the jury sees. So the judge is she couldn't open the video on her work computer that morning. This reinforces the file as unusually large or encoded and in a difficult format. This is why it's important for the lawyer's assistants or clerks or whatever you call them. What are they called? Legal assistants, or whatever. Their tech guy. Do you remember that tech guy that was sitting there behind them? He should have double checked and made sure that these files were not too large and were able to be opened. And if it was, he saved it in a format that was easier to open and or work with the court's system. That was his job. So the judge right now, the exhibits must be physically accessible. Stickers must go on them, not on the packaging. Technical failures can derail the proceedings. The video evidence is very fragile, and the judge is maintaining control. She paused the trial, ensured the equipment is functioning, and prevents the jury from seeing distorted or incomplete evidence. That is vitally important. All right, here we go. Court, isn't this just straight hearsay objection? Let's go back and look at what was said. Question, and as far as what, if any, there's our what, if any, was the call in reference to, if you know the answer? He stated, there is your hearsay. He stated he was driving in the area of 34 Fairview because of the warm weather and the warm rain in the last couple of days. Question, and what, if any, did he indicate to you that he saw? Objection! Sustained. I'm going to see you at sidebar. So that is where we are. I know you were waiting for the what, if any. Isn't this just straight up hearsay objection? Jackson, correct. So I understand this might be the knowledge of the police officer, but hasn't laid a foundation for that. Lally, okay, really? I'm trying to establish the witness, Your Honor. Is that essentially there was? I'm trying not to get too much into it. It just more he then. I don't understand the way did he really talk this way? It doesn't make much sense to me. It's just more he then directs Berkowitz to Lank. Lank recovers the item. That's all. Court. So you've got Lank testifying, correct? Did Lank give you the item to this witness? Lally. No. So Lank photographs the item and leaves it in place until the state police show up. Sergeant Kinney is the one who came and retrieved it. Okay, yes, you're not going to do that. Lally, no. All I want from him is to get from Berkowitz to Lank. That's all. The court. And how do you get from Berkowitz to Lank with him? Lally, because he is the one that indicates to Chief Berkowitz that Lank is the one who is working that day. So you already have it. Exactly. Okay, we'll end up on that point. This was an interesting bit of questioning, and this is also an interesting little tidbit. The Commonwealth is trying to elicit testimony about how an item was recovered at the scene and moved from an officer to another officer. The defense objects to hearsay grounds. The judge must determine whether the testimony is admissible and whether the Commonwealth has laid proper foundation. Number one, the issue presented. The Commonwealth wants the witness to testify about what someone told him about who recovered an item and how it was moved from Officer Berkowitz to Officer Lank. The defense, hearsay. The judge immediately asked the question, isn't this just straight hearsay objection? And they agreed. The judge acknowledges information might be part of an officer's knowledge, but the Commonwealth has not laid a foundation showing how the witness knows whether he personally observed it and whether he firsthand knowledge. Without the foundation, the testimony is inadmissible hearsay. The Commonwealth attempts to salvage this testimony. Lally tries to narrow the purpose, and that is all he can do. He is saying he's not trying to get into details. He only wants to show the witness directed Berkowitz to Lank, and Lank recovered the item. He frames it as simple chain of event point. But Canoni drills down on the key evidentiary questions. So you've got Lank testifying. So if you have a person testifying, the other person cannot testify to what that person can testify to. A cannot testify to what B can testify to. So this is crucial. If Lank testifying, then Lank can describe what he did. Lank can authenticate the recovery of the item. Lank can explain the chain of custody. There is no need to use hearsay through this witness. Now, what if Lank had passed away? He had a stroke, heart attack, and died. Then you can use this as a hearsay. But that is about all. So the judge did ask, did Lank give the item to the witness? And Lally said no. Lank photographed the item. He left it in place, and Sergeant Kinney retrieved it. This confirms the witness has no personal involvement, no firsthand knowledge, and no role in the chain of custody, and no admissible bias for testifying about it. So the judge ruling is okay. Yes, you're not going to go there. You're not going to do it. She shuts him down. And that line of questioning is done. Now, the Commonwealth tries one more time. Lally insists he only wants to show the witness told Berkowitz that Lank was working that day. He's backpedaling here. The judge asks, and how do you get from Berkowitz to Lank with him? Lally answers, witness told Berkowitz that Lank was the officer working. The judge's response was, so you already have it. Exactly, Lally says. The judge final instructions, okay, well, we'll end it at that point, meaning you ain't going any further. The witness may testify to the only non-hearsay that he, the witness, told Berkowitz who was working. Nothing more. No hearsay about what Lank did, no chain of custody testimony, and no statements from others. The sidebar is a textbook example of straight hearsay being shut down, missing the foundation, which was Lank's actions, the item recovery in the chain of custody, avoiding cumulative and improper testimony. Since Lank will be testifying, the judge prevents duplicate testimony, hearsay, and confusing the jury. So that was a good hearsay shutdown. And I loved every minute of that. What's the objection? I love it. She does this a lot. Oh, what the hell is your problem? What's the objection? Well, first of all, Lally says, knowledge of this witness, whether or not he knows Lank knew or that Lank did prior to him getting there. Secondly, I court, is this a report? Isn't it in a report that Lank wrote? Lally, I'm sorry. Court again. Is it in the report that Lank wrote that he would have known about? Jackson, generally, yes. If he had reviewed all the reports, he would know. This lieutenant would know. As a supervisor, that Sergeant Lank had certain relationships or had relationships which he testified to with the Alberts. Ooh, uh-oh. Canoni, I understand that, but your question was whether he knew what he had done before he got there. Jackson, correct. The only way that he would know that is if Lank had informed him. I've already interviewed these folks, and that's what I want to find out. Why did you task him to do something that had already been done? If he says, I don't know, then I'll live with that. The court, all right. So the question was asked. So the question that was asked, you can ask. Okay, I'm going to allow it. Okay, thank you, Your Honor. Let's see what he does. Question. Lieutenant, just before you went to sidebar, I asked a quick question. Were you aware at the time that you tasked Sergeant Lank to go talk to folks in the house that he had already gone into the house to talk to them? He said, yes, I did. You indicated that one of the reasons I'd like to move back. I'm bouncing around a little. My apology. I understand. One of the things you talked about was the preservation of the crime scene and the lack thereof because of the inclement weather and inclement conditions. Okay, so let's talk about this. This is kind of important. The issue here is whether he knew Lank had already done before he did, the lieutenant arrived. The Commonwealth objects on two grounds. One, the lack of personal knowledge. Lally argues that the witness cannot testify what Lank knew, what Lank did, or what Lank had completed before the lieutenant arrived. I'm sorry, y'all. Lally begins with the second point, but is interrupted by the judge. The judge first question, is this in a report? The judge immediately asks for a key evidentiary question. Is it in a report, quote, Lank wrote that he would have known about it? This is the judge's probing whether Lieutenant knowledge comes from the official reports, which he would have reviewed as a supervisor. If so, the lieutenant may have a legitimate basis to answer. The defense's position, Jackson explains, as a supervisor, the lieutenant would have reviewed all reports. Therefore, he would know what Lank documented, what Lank's relationship to the Alberts was, and the investigative steps that had taken place. Guys, my bangs are itching me. I'm going to reposition. Thank you. Sometimes they itch. They get a little itchy. But Jackson clarifies the specific purpose of the question. He's not asking what Lank did. He is asking, quote, do you know whether Lank already interviewed the people before you assigned him to do it? This is supervisory knowledge question, not a hearsay question. And that is a very good point. Jackson's reasoning is the only way the lieutenant would know if Lank told him. If the lieutenant says, I didn't know, that's fine. If he says, I did know, that also is fine. Jackson wants to explore why the lieutenant tasked Lank with something that he may have already done. This is a legitimate line of cross-examination. In the judge's analysis, the judge distinguishes between asking what Lank did, improper, no personal knowledge, versus asking what the lieutenant knew, permissible supervisory knowledge. The judge notes that Jackson's question was about the lieutenant's knowledge, not Lank's actions. That's proper subject for cross-examination. So the defense, what this means is that the defense may ask whether a lieutenant knew what Lank had already done, whether Lank had told him he had already interviewed certain people, why he has assigned Lank to task that may have already been completed. The defense may not ask what Lank actually did, what Lank knew, and what Lank said, unless it fits a hearsay exemption of non-hearsay purpose. Okay? I can keep going on this. This is amazing. This particular one really got me doing my homework, and I thoroughly enjoyed that task. Are you guys enjoying the commentary? Are y'all following along? Is this something that you are liking? Because this is what I love to do. I love to break it all down. All right, the next one. All right, we're off and how long things might take this morning. Does it make sense? So Lank is your next witness. Let me get my mouse where I need it. Lally, yes, court. How long do you expect this witness? It could be equal, Lally states. Does it make sense maybe before, after lunch of the witness? So does this witness will go past lunch, Lally? I think so, yes. There's Yannetti. There's no doubt. Court, and you're cross. She's like, I'm ready for food. I don't care about this. All I care about is lunch. Yannetti, it's probably about the length of Mr. Jackson, I would say. Court, all right. So maybe we'll send the jury home early and do our voir dire of Lank when we finish with this witness. Okay. Court, I mean, do you have a short witness in between? Yannetti, in between? No, but I think Lieutenant Ray, I think is relatively quick. All right. Let's see what time it gets to be. But I'd like to do is voir dire today and have Lank on tomorrow rather than Lily. Sure. Okay. That makes sense. Do you do a quick voir dire about it? Okay, sidebar done. Now, this voir dire was very, very, very important. So the issue was whether the detective Link was going to be there today. The current witness was running past lunch, yada, yada, yada. This was anything major. It made sense to finish the current witness, send the jury home early to conduct the voir dire later today, and that is exactly what the court did. It was interesting. I wish I had the time to replay that entire trial because it was so different from the second trial. It really was. The court was really different from the first trial. It was just amazing. Can I see it, Mr. Yannetti? Sure, of course. That is the beginning of the report, and that's the paragraph. Let's go back and look at what they're talking about. Well, I'm just asking you. I'm dealing with the state police report. That's a report that lists you as a primary investigator with regarding the reconstruction, Mr. Lally. Objection, Your Honor. There's the approach. Can I see it, Mr. Yannetti? Sure, of course. This is the beginning of the report. That's the paragraph. Who wrote the report? Yannetti. Not Sergeant Good, somebody else. Court. Right. I know from state police, but why don't you take that and tell me the author while I read this, Lally? It's Trooper Paul, Your Honor. Yes, Trooper Paul, Yannetti. Okay. Is this your witness list? Is he on your witness list? Lally, yes. Court, okay. So someone of what causes different difficulty is asking a question of a wrong witness. Yannetti. So he didn't adopt any of this, right, Lily? That's really not what the report says, Your Honor. He has nothing to do with the reconstruction. In any reconstruction report, they are going to list who the primary investigator is with the involved department. So whatever they spoke to on the scene or whoever wrote this of the report is going to be listed in the recon report and preliminary investigator. That does not mean he didn't have anything to do with the reconstruction, Yannetti. I can ask another couple. I didn't know that, but what was that? Lally, I would assume Mr. Yannetti knows this. Yannetti, I did not. I ask another couple of questions just to get out of it. I'll move on. Okay. So this was interesting. The defense is attempting to impeach or question Sergeant Good using a report he did not write. Who wrote the report, Yannetti? Not Sergeant Good. Somebody else did. So it was Trooper Paul. This triggers a core evidentiary problem. A witness cannot be impeached with a report they did not write or adopt. Adopt meaning addendum or added information to. So the judge is analyzing this. You're asking the wrong witness. Some of what caused difficulty is asking question of the wrong witness. So the key point is Good didn't write the report. Good did not adopt the report. Good is not responsible for the contents of the report. Therefore, he cannot be questioned about statements within the report. This is a foundational rule of impeachment. You can only confront a witness with their own prior statements. That is what impeachment is, or statements they adopted, took on, modified the report. So he goes, someone else wrote the report, he adopts it by taking it and adding or more information to it, and he signs his name. That's an adopted report. The statements have to have personal knowledge of. The Commonwealth's clarification why Good's name appears on the report, Lalia explains. In a reconstruction report, the state police lists the primary investigator, even if the person had nothing to do with the reconstruction. So as the main and lead investigator, his name is going to be added to the report, even though he was not there during the reconstruction. He had no personal knowledge of it. The report lists Good because he's a primary investigator for the department, not because he contributed to the report, not because he wrote or reviewed the report. This means the appearance of Good's name does not make him the author. It does not make him responsible for the contents. Wrong witness. And the defense's response was he did not know about the report was authored by Trooper Paul. He will ask another couple of questions and get out of this. In other words, oh shit, I stepped in manure and I didn't know I was stepping in. So the defense may ask a couple of cleanup questions to avoid leaving the jury confused, but the defense may not continue questioning Good about the report because he is not the author, nor did he adopt it. This is procedural significance as Sidebar reinforces several key evidentiary principles. You cannot impeach a witness with a report they didn't write, author, adopt, or personal knowledge of. You can't impeach. He's listing someone in the report does not equal authoring of said report. This doesn't have a page number. Let me go down. I need to do this for a second. How are y'all doing? We are going to tidy this up in the near future. I'm at the end of this one because it's coming up on almost midnight my time. 247, 224. But my notes do not give a page. Okay, let me read. Yep, this is where I need to be. Okay, let me embiggen it. So is this format flowing good for you guys? I am good while pushing and trying. Are y'all doing good with this? I know we don't have a whole lot of viewers. It's kind of late at night for us. All right, but I'm enjoying this. And I'm just glad we were one of the first to do it. Okay. The court. You ready? If there's no objections to it, I'm going to let it in. Only have one question. Mr. Yernetti. The court. So it's been altered in that it says as read, Officer Sarah's dash cam and Officer's Goods dash cam. Their own dash cams don't say that. They're just numbers. Yannetti. True. Court. And it's two of them spliced together or put together. Are there any other alterations to this? No. It's just only wording. That's it. Jackson, the labeling and the synchronization. That's it, Yannetti. Yes, that's it. Court. All right. Thank you. That will be admitted into exhibit. Now, this can be a little bit tissy. The Commonwealth seeks to admit a video complicated but combines Officer Seraph's dash cam footage and Officer Good's dash footage at the same time. The judge is pausing to confirm the nature of the extent of the edit before allowing it into evidence. The issue presented here is the judge is prepared to admit the evidence if there's no objection. But she has one critical question. Has the video been altered in any way beyond the labeling synchronization? This is standard evidentiary safeguard. Edit and splicing videos must be disclosed. The court must confirm the edits, and the jury must not be misled by labeling and that not exists on the original recording. The judge's concern is that the labeling is not original. And she says their own dash cams. I keep getting buzz. Their own dash cam doesn't say that. They're just numbered. So the original dash cam files are numerical file names. The edited complication now displays Officer Seraph dash cam, Officer Good dash cam. This alteration, even benign, must be made known to the jury. The judge does confirm the labels are the only edit, splicing transparent, and no content has been changed. Yannetti confirms and agrees the Commonwealth Jackson ADA clarification that the labeling and synchronization is all. The edit video must be disclosed and explained. The court must know what was changed, why it was changed, and whether the edits are substance or presentation. Labels added are clearly permissible. Synchronization is allowed, and the judge is protecting the record. All right. Okay, another one. Yannetti. No court. I just want to say the reason I wanted you to come to Sidebar, Lally, sure, the court. If the Commonwealth tried to put a police report, I wouldn't shoot them right down. Yannetti, I understand the court. So what are we doing with the screen and why are you reading to him? Yannetti. Okay, so the portion that I just read is essentially all I'm going to ask him. What page are you on? Because I have the court. Yannetti, it's on the first page. It shows the incident number, the call number, the date and time of the report date and time, reporting officer. That's it. That's all I was going to read from. And then I was going to reference the photo. Where I'm going with this, Your Honor, is that his identical information that I have him corroborating the alternate and changed. We blocked out any, compromising information. I'm not seeking any other portion of the report, but I'd like to show the jury that and the close-up of the photo. Show the jury this and the close-up of the photo court. What is that? Yannetti, this actually shows a piece of the taillight that was not in the original photo. It is completely different photo court. Okay. You've shown him this yet? Yannetti, he has not seen this yet. Court, all right. Is there objection to just continuing here and showing that one photo? Lally, I have no objection to showing a photo to the witness, but I don't want the photo going on the screen. The court, all right. So you're going to have to show him this. It's late in the day. How much longer are you going to have with him, Yannetti? I mean, I think I might be able to finish by 4. No, apparently not. I don't have that much more. Probably more like 15 minutes. Court, why don't we bring him back tomorrow and deal with this issue, all right? He's going to have to look at it. I'd like these marked. I'd like to have a voir dire of length today. He's here, right, Lally? I believe he was. My concern, Yannetti, my concern, Your Honor, from a strategic standing And also with regards to sequestration, I have now shown my card. The court. I don't think you have because it wasn't at all clear to me what you were doing. Yannetti, I get that. My point is, I don't want Commonwealth to be revealing to the witness where I'm going with this. Court. He won't. Yannetti. Okay, that's all. Court. Otherwise, I don't know when we will get to the voir dire end. I think that's important. Yannetti, understand, court? So does this seem like a good place to end then with him, Yannetti? That's fine, Your Honor. Yes, we can do that. All right. Now, this is when they went into Yannetti. Then they went into the voir dire. Give me a second. Sorry, guys. I was having a leg cramp. Ah! Shit! Y'all awake? Wake up, everybody. Wake up. Okay, the defense cross-examination of the police witness included redacted portion of the police report and wanted to show the jury different photo. That contained a taillight fragment not visible in the original photo. Now, the judge calls the sidebar to clarify what was being read and being shown and whether the witness has seen the new photo. The judge also weighs sequestration concerns and also needs to conduct detective lengths voir dire. So the Commonwealth tried this. I'd shut it down. That judge is giving a warning. If the Commonwealth tries to put a police report, I would shoot them right down. This is a judge's reminding everyone. Police reports are hearsay, and that's important for everybody to understand. And this is something that a lot of people don't understand, and a lot of people believe and think that that is actual hardcore evidence. So if you ever find yourself in a situation where you're in court and a police report is being brought in and they're treating it as the truth, your lawyer better be bringing up hearsay, because a police report is hearsay. It is not fact. It is not evidence. It is the synopsis of the police officer. He's going in saying, this is what I said. This is what I heard. This is what I ... It is not actual evidence. It is hearsay. Now, they are not admissible as exhibits in a criminal trial unless it's offered for non-hearsay purpose. Hear me. This is huge. I was in a traffic court and the cop tried to bring up the police report, and the lady's attorney stood up and said, Your Honor, this is police reports are not evidence. They're hearsay. And she won the case. Or they can use to refresh a recollection. They can sit there and say, okay, this is a police report. I want you to read it. Not out loud to yourself. Does it refresh your memory as to the events of that day? That's pretty much what a police report does. Or it's used for impeachment of an officer who wrote them. Here, the witness did not write the report, so the judge is making sure you're not trying to sneak in inadmissible evidence. The other thing the judge says is, why are you reading it to him? He's really not supposed to be reading a report to him. He can offer the report, have him read it to himself. The judge wants to know is what portion of the report are you reading? I may have to go get more fluids. Why are you reading it? And whether it's being used to impeach, foundation, or something else. You need to clarify, the judge is saying. You're only reading the header information, incident number, call number, date, report, offense, officer. You're not trying to admit the report into evidence. And she's saying you're not using it to corroborate the witness's own information. You've redacted all sensitive content. This is very important. And then the judge is satisfied. So now they move on to the photo, a different image with a taillight fragment. Now, in quotes, this actually shows a piece of taillight that was not in the original photo. It's a completely different photo. The judge is asking key questions. Have you shown this yet? The answer was no. Why is this critical? Because a witness cannot authenticate or comment on a photo they've never seen. You cannot publish a photo to the jury before the witness identifies it, and the judge must protect against surprise or prejudice. And so he can take the photo, hand it to the witness, and say, have you seen this before? Yes. Do you recognize what's in this photo? Yes. He can authenticate it. They can move it to be admitted into evidence, and then it can be published. Until that process happens, he can't do that. Now, Lally says he has no objection to showing the witness the photo, but he does not want the photo displayed to the courtroom screen yet. Why? Because it's not been properly authenticated, and it has not been admitted into evidence, and it has not been what's the word I'm looking for? I lost my word. It's not been admitted into evidence. But this will avoid the jury exposure before the foundation is laid. Okay? The judge's time management, well, we understand that. Wait, I don't need to rehash the time management. So now we're going into docket number 12, and we're going to stop here because I'm not done with docket number 12. And the next time we do this, we'll start at number 12. We have day 7 through 22, but there's, I think, day 14 or 17 has A and B, and then 22 has A, B, and C. So we have 13, 14, 15, 16, 17A, 17B, 18, 19, 21, 22, A, B, C. So we have about 14 more days of this to go through. So with that, did y'all have fun? Did y'all enjoy this? Do you want me to do more? Let me know in the comments below. I am so blessed to have each and every one of you here, but I'm even more blessed to have my mods. My mods are the freaking best, simply the best, better than all the rest. So, I'm glad you're enjoying it. Sidebars are very interesting. You learn a lot about a trial when you go back and look at the sidebars. What I wished I had the ability and time to do, but we just don't have the time for it, would be to go in and find in the video where the sidebar happens. But, I don't have the capability. I would need a producer to help me with that, and I don't have a producer. My mods and I produce all of this on our own. They are my producing partners, I guess. And that would just be astronomical amount of work. So what I have done now is a lot of work, because what I've done is I've gone through and I've looked at every sidebar. I've researched the sidebar. I pulled up the rules that apply to the sidebar, and I've made my commentary. So this has been a lot of hours in the making. And not only that, my mod June went through read every word of thousands of pages, because each one of these are 200 and 300 and 400 pages per day. So she's read a lot, and she has gone through and highlighted every sidebar. Then I've gone in, found all those sidebars, and created my commentary. So I have done a loose leaf of preview, and now I'm going in and cleaning it up. So tomorrow is Christmas Eve. I don't think we'll be on tomorrow, and we'll not be on Christmas Day. The day after, the rest of this 26th through the 30th, 31st, I have got to clean up my sister's house. I've got some done, but I have to depend on other people to get part of it done because they're picking up furniture and Got to drop everything off at all these Salvation Army, Goodwill, St. Vincent de Paul, you name it, I got to do it. Yay! we've gained some subscribers. We're up to 3,516 subscribers. Oh my gosh, y'all are so amazing. I'm so happy. Thank you so very much, subscribers. We love you. Now become members. We do have a membership. I am, as most of you know, I have graduated. I am job seeking right now because I have to work. This doesn't pay bills. This is what I love to do. If I could do this and pay bills, I wouldn't work, but I got to work. So we will be changing our format. We are going to be launching in January. Last January, I changed my look a little bit. We just kind of refresh our YouTube channel. So we'll be looking for that. We are going to be changing our format a little bit, but we're so grateful and thankful that you're here. I'm trying to gain more evening viewerships because I will be doing more evening lives due to my work, whatever and wherever I work. Now, if I could find a way to work at home and do this and do that, that would be so phenomenal for me to work at home all day long and have this going in the background and us watching court, and me working and commenting and doing all of that. That would be awesome, but I don't think that's going to happen. Yeah. That would be nice to work remotely and be able to do both. That would be phenomenal. That was my dream. That would be my dream. Do a remote job, and that would be awesome. We started tonight. I just want to say that again, we are praying for the Melody Buzzard, who was found. Her body was found, and her remains of a 9-year-old girl whose mother shot her in the head multiple times. So we will be covering that case. Everybody, thank you so much for joining. Y'all have a fabulous Christmas Eve, amazing Christmas. And also, for some of us who are alone on Christmas, we're here in Discord. If you find that you are alone and you need to be with somebody, you need to talk to somebody, you need to communicate, you need to be around some people, and you don't have that, here's our QR. This is our Discord link. Join our Discord. You can always get us there. We also have movies. Cowboys Play Thursday. But we also have movies. June and Angela had movies on, some of the old movies all day today. So don't be alone. Don't reach out. We'll be happy to spend time with you. Okay. Nobody deserves to be alone on Christmas. So we're here. We watched 2 black and whites, and it was awesome. It was awesome, and I fell asleep. I fell asleep at 5:36. I fell asleep. I got a call from my mods waking me up that we had breaking news, and I thought I was getting up. It was interesting. Usually I don't go to take a nap, but I did today. All right, guys, love and blessings. Merry Christmas. If I don't see you before then, have a fabulous day, and we'll see you later. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.